4. Authority and authorities. 4.1 The idea of authority. We have discussed rules and precedents in separate chapters because they differ in significant respects. Yet rule-governed and precedent-following decisions have much in common, including that both are backward-looking. Rules made in the past control the events of the present, and following a rule made previously is different from making the decision that now appears to have the best consequences. So too with following a precedent, which involves adhering to an earlier decision as opposed to deciding what will be best for the future. The backward-looking aspect of these modes of legal thinking is closely related to the concept of authority, for rules and precedents not only pull us backward, but also force us away from our own best judgment in favor of someone else's. When a court follows a rule, it does not decide for itself whether the rule is a good or a bad one. Nor does the court decide whether in this case to obey the rule. Instead, rules function as rules by excluding or preempting what would otherwise be good reasons for doing one thing or another. Judges following a rule look to the rule instead of the intrinsic merits of the case. A police officer enforcing a speed limit rule is expected to focus on whether a driver was exceeding the speed limit and not on whether she was operating the vehicle unsafely. The Bureau of Land Management official who first rejected Mr. Kell's filing because it was a day late did not evaluate whether it would be good, all things considered, to accept this petition from this claimant at this time. He simply found that Locke had not filed prior to December 31. Just as rules exclude at least some of what would otherwise be considered in making a decision, so do precedents. A lower court bound by Macpherson v. Buick Motor Company is not expected to determine whether it is wise to impose liability on a manufacturer when there is no privity between manufacturer and consumer. And the judge who understands that Roe v. Wade is binding precedent knows that he is not to decide whether a complete ban on abortion is morally permissible, morally mandatory, or even constitutional. In these situations, it is sufficient that the precedent exists, for the very existence of a binding precedent precludes reevaluation of its wisdom and forecloses deciding whether following the precedent will produce the best result in the instant case. With respect to both rules and precedents, the key idea is that they are authoritative. Their force derives not from their soundness, but from their status, and philosophers of law refer to this feature of authority as content independence. When a rule or a command, an order, or an instruction is authoritative, its subjects are expected to obey regardless of their own opinions of its wisdom. In other words, what the rule says does not matter. Where it comes from makes all the difference. When an exasperated parent yells, "Because I said so," to a child, the parent may well have first tried to explain to the child why she should do her homework or clean up her room. Only after such attempts at content-based persuasion have been unavailing does the parent resort to the "because I said so" argument. And he does so precisely to make clear that the child should do as told whether the child agrees with the reasons for doing it or not. And so too in law, where the legal system demands that its judges and the rest of us as well follow, even those rules and precedents that they think mistaken. Law's subjects are expected to obey the rules and precedents because of their source and status, regardless of whether they are persuaded by the content of their reasoning. And even if they are not persuaded by the content of their reasoning, it is worth pausing over the unusual nature of content-independent authority. In most aspects of our lives, we base our decisions on the substance of the reasons we have, and not on where those reasons come from. I eat spinach because it is good for me. Judge Cardozo decided the way he did in Macpherson v. Buick because he thought that outcome fairer and more efficient than what had previously been the law. These reasons that spinach is good for me, that not requiring privity as a condition of liability for certain consumer transactions is fair are substantive reasons. Sometimes these are called first-order reasons. They go directly to the content of the reason. If I did not think spinach was good for me, and assuming I did not like its taste, I would not eat it. And Judge Cardozo would not have reached the result in Macpherson if he had thought it unfair or bad policy. Normally, someone considering what to do or to decide will take a reason as a good substantive reason only if she believes in what the reason actually says. Content-independent reasons, however, are different, precisely because what the reason says does not matter. It is the reason's source, because I said so, that gives it its power. Like parents, those in authority often rely on their official or formal role to provide the content-independent reasons for subjects to follow their commands or instructions. Sergeants and teachers, for example, may initially try to induce their subordinates or students to understand and internalize to take on as their own the substantive reasons for doing something. The essence of authority, however, exists not because of such internalization, but apart from it. Perhaps the sergeant would like me to understand why I should have a sharp crease in my uniform pants. And surely the teacher would like me to see why I must memorize a Shakespeare sonnet. But in these and myriad other cases, the authorities wish it to be understood that I am to do as I am told just because of who told me to do it, even if I neither accept nor agree with the underlying substantive reasons for doing so. It is controversial whether exercising or following authority is a good idea, and if so, in what contexts. Over the years, many have argued that it is irrational for someone to do something she would not otherwise have done just because a so-called authority dictates it. If Barbara has decided after careful thought to spend her life as a lawyer rather than as a physician, why should she act differently just because her father tells her she should? When Sam has concluded that he would like to smoke marijuana because he believes it makes him feel good and has few side effects, is it rational for him to put aside his own best judgment in favor of that of police officers and politicians? If an electronic signal says, "Don't walk," and there is no car in sight, does it make sense for me to stand obediently at the curb? And when a judge has determined what she believes would be the best result in the case before her, can it be rational for her to make a contrary ruling solely because a bare majority of judges of a higher court came to a different conclusion in a similar case? Authority may be ubiquitous in our lives, but for generations its basic soundness has been an object of persistent challenge. Yet although authority has long been criticized, it has for just as long been defended. Socrates refused to escape from Athens on the eve of being put to death precisely because he accepted the authority of a state that had unjustly, even in his own mind, condemned him. President Eisenhower sent federal troops to Little Rock, Arkansas, in 1958 to enforce a Supreme Court decision, Brown v. Board of Education, with whose outcome he disagreed. And he did so because he accepted the authority of the Supreme Court, just as he expected the state of Arkansas to accept the authority of the federal government. Questioning the idea of authority may have a long history, but there is an equally long history of people accepting and defending it. The ultimate rationality of authority is not our principal concern here, nor is the question of the legitimacy of state authority in general. Knowing that authority is controversial, however, is important precisely because so many legal debates, both in court and out, are about the extent of law's authoritativeness. The debates about whether United States v. Locke was correctly decided, and indeed the debates among the justices in the case itself, are about the extent to which, if at all, a sloppily drafted act of Congress should be taken as authoritative, mistakes and all, just because Congress enacted it. Likewise, the question of when a court should overrule itself is about the authority of past decisions, and the debates over judicial responsibility for enforcing the fugitive slave laws, the laws of Nazi Germany, and the racial laws of apartheid South Africa are debates about the authority, if any, of immoral law. So although explicitly philosophical treatments of authority rarely surface in legal argument, the fact that authority itself is deeply contested is a looming presence in the operation of the law, because content-independent authority lies at the heart of legal reasoning and argument. Lawyers do try to convince judges that their client is substantively right, but the language they use is the language of authority. The good lawyer will encourage the judge to see the substantive justice of his client's position, but he relies on the authority of rules and precedents as a way of saying to the judge that she should rule in his client's favor, even if she disagrees that it is the right substantive outcome. In law, the concept of authority is typically associated with legal sources. Indeed, legal sources, constitutions, statutes, regulations, and reported cases most commonly are often referred to as authorities, whether they are used in an authoritative way or not. For example, what American lawyers call a brief, a written argument on a matter of law, is sometimes referred to as a memorandum of points and authorities. In this broader sense, a legal authority, not only a constitution, statute, regulation, or reported judicial opinion, but also at times a learned treatise or an article in a law review, may sometimes be used not because it is authoritative, but because it is a repository of genuine wisdom, experience, or information. A citation in a judicial opinion to a pithy phrase from Holmes or Cardozo, for example, may differ little from a speech in which a member of Congress quotes Abraham Lincoln or Winston Churchill. Thus, we should not be seduced by labels into thinking that everything called an authority in legal argument is being offered or used for reasons of its authority. Just as there is an important difference between learning how to do something from a book and taking something in that same book as correct just because it is in the book, so too is there an important difference between authority-based reasoning and the various other uses to which legal decision makers may put a host of published materials. But although legal arguments and judicial opinions often use sources in this non-authoritative way, law remains pervaded indeed, characterized by the use of genuinely authoritative sources. Such sources, unlike quotations from famous judges or references to the law of other jurisdictions, provide reasons for making a decision in a certain way by virtue of their very existence and not of their content. And so, although these source-based and content-independent reasons will often be consistent with what a judge would have done even without them, sometimes they will not. Relying on genuinely authoritative sources may thus dictate that a judge make a decision other than the one she would have made herself, even after taking into account all the wisdom and information that she can obtain from her own knowledge and that of others. And in this way, legal reasoning differs, in degree even if not in kind, from the reasoning in other decision-making environments. In other decision-making environments, authority may play some role, but first-order substantive considerations typically dominate. In law, however, authority is dominant, and only rarely do judges engage in the kind of all things considered decision-making that is so pervasive outside of the legal system. Far more commonly, legal argument relies on sources, not only because the law treats so many of them as authoritative, but also because the way in which legally authoritative sources replace first-order substantive considerations remains the touchstone of legal reasoning, for to unbinding, and so-called persuasive authority. Once we understand that genuine authority is content-independent, we can see that persuasion, on the one hand, and the acceptance of authority, whether voluntarily or not, on the other, are fundamentally opposed notions. To be persuaded that global warming is a problem, or that freedom of speech encompasses the right to encourage racial hatred, is to accept as sound the substantive reasons for those conclusions. And when we are genuinely persuaded by substantive reasons, we have no need for authoritative pronouncements. A scientist who concludes that global warming is a problem does so not because 7 Nobel Prize winners have said so, but because her own investigation justifies the conclusion. But when I conclude that global warming is a problem, it is not because I genuinely know it to be correct, for I have no authority-independent way of knowing. Rather, I reach that conclusion because it is what many authorities whose authority I accept have said. It is not that I am persuaded that global warming is a problem. It is that I am persuaded that people whose judgment I trust are persuaded that global warming is a problem. The same distinction permeates the law. It is one thing for a public official or lower court judge to believe that the best understanding of the principle of freedom of speech permits the advocacy of racial hatred. It is quite another to conclude that advocacy of racial hatred is to be permitted in the United States because the Supreme Court said so in Brandenburg v. Ohio. In the former, the substantive reasons are doing the work, while in the latter it is authority pure and simple. A lower court judge must follow Brandenburg, even if he thinks it mistaken, and even if his own legal analysis leads him to conclude that advocacy of racial hatred is not constitutionally protected. The precedent is cloaked with authority, and so the judge is obliged to obey it regardless of what he thinks of its soundness. Precedents like Brandenburg are typically referred to as binding. A lower court judge is bound or compelled to follow them. Or, to be more precise, binding authorities are those that a lower court must follow or distinguish, just as a lower state court in New York must follow Macpherson v. Buick or explain why the current case is different. The court is not permitted to concede Macpherson's applicability, but refuse to apply it. Nor may it overrule Macpherson. It must follow Macpherson, just as it must follow the Constitution of the United States, the Constitution of the State of New York, and any applicable federal or New York statute. And because the court has no choice about whether to follow such authorities, they are sometimes referred to not as binding, but as mandatory. They are mandatory in the sense that they must be used, and in the sense that they must be followed. The briefest glance at almost any judicial opinion, however, will show that courts often support their arguments by references to various decisions and other sources that they are bound neither to use nor to follow. A New York State court may cite to a case decided in Vermont, just as the United States Court of Appeals for the Third Circuit may refer to cases from other circuits or from the district courts of its own circuit. The courts are not even required to cite to these authorities, let alone follow them. Not only is the Third Circuit not required to follow a similar case in the United States District Court for the Western District of Virginia, it is not even required to acknowledge its existence. Yet such citation to non-binding sources is ubiquitous, and so too is citation to legal treatises and articles in law journals. Such secondary sources, like the decisions from other jurisdictions, are commonly found in judicial opinions, but no judge is required to use or even to refer to them. And the judge who supports a conclusion with reference to a learned treatise or law review article is referring to a source whose use is entirely at the discretion of the opinion-writing judge. Sometimes cases from other jurisdictions and from lower courts, learned treatises, law review articles, and non-legal sources like dictionaries, newspaper articles, and journals from non-legal disciplines are referred to as persuasive authorities, the idea being that a court will use them only if it is persuaded by the reasoning of the cited source. But if the court citing such material is genuinely persuaded, then it is misleading to think of the sources as authoritative at all, for persuasion and authority are fundamentally opposed notions. It is far better to describe these non-binding sources as non-mandatory or, more felicitously, optional. As we will see in the next section, referring to mandatory authorities as binding is somewhat misleading as well. A better and more accurate distinction than the one between binding and persuasive authority, therefore, is one between optional and mandatory authorities, for the real difference is whether the decision-maker has a choice whether to use the authority. In a products liability case in the Minnesota State Courts, a law review article about Minnesota products liability law is obviously pertinent, but its use is optional in the same way that an Arizona products liability case dealing with very similar facts would be optional in the Minnesota courts. By contrast, a Minnesota products liability statute is also pertinent, but a Minnesota court has no choice but to use it. The distinction between mandatory and optional authorities explains why a judge in the United States District Court for the Southern District of New York is required to follow Second Circuit Court of Appeals and Supreme Court decisions, but not required to follow the conclusions of the Eastern District of New York, the New York Court of Appeals, the Third Circuit, Wigmore on Evidence, the Harvard Law Review, the High Court of Australia, or the European Court of Human Rights. Although the sources in this latter set are permissible, even if not mandatory, their permissibility distinguishes them from a host of impermissible sources. The Southern District Judge may not be required to cite or rely on Wigmore on Evidence, but it is noteworthy that reliance on Wigmore is permissible in a way that reliance on or citation to astrology, private conversations with the judge's brother, and articles in the National Enquirer is not. It is thus not sufficient to distinguish mandatory from optional authorities, for distinguishing optional yet permissible from impermissible sources is also essential, as we shall see in section 4.4, for understanding the nature of legal argument. But first there is more that needs to be said about optional authorities. It is true that optional authorities are ones that a court is not required to use. But if a court is not required to use an optional authority, then how does it select an optional source? And is there really no difference between an optional citation to an opinion from a court of appeals in another circuit and an optional citation to a quotation from Abraham Lincoln or Woody Allen? With respect to some uses of optional sources, the judge might use and cite to a source because she is persuaded by the reasons the source offers in support of the source's conclusion. But then the source, the authority, is not being used as an authority, and little differentiates the persuasive opinion of a court in a different jurisdiction from the persuasive opinion of the judge's father-in-law. Good manners and the desire to give research direction to others will often counsel the judge to acknowledge the source of what she has now taken on as her ideas and conclusions. But the citation of the decision of another jurisdiction seems not to be a reliance on authority, as we now understand the idea of authority. It will instead be the judicial equivalent of an academic paper that gives credit to the origins of the author's thinking. If an optional source of guidance is used because of the user's belief in the substantive soundness of the source's reasoning, therefore the source, even if by tradition and convention it is labeled an authority, is not being used as an authority. But although this conclusion appears to make the idea of an optional authority as self-contradictory as that of a persuasive authority, there remains another interpretation. Although optional authorities are sometimes selected because they are persuasive, more often they are selected as authorities because the selector trusts the authority as an authority, even if he does not agree with the conclusion or, more likely, believes himself unreliable in reaching a conclusion on which the authority, whether commentator or other court, is thought more reliable. So although a Tenth Circuit judge is under no obligation to rely in securities cases on conclusions reached by the Second Circuit or found in Loss and Seligman's treatise on securities regulation, the judge might think that her own judgments about securities matters are unreliable enough that she would prefer to rely on a court or commentator she believes to be more expert in such matters. The Tenth Circuit judge who looks to the Second Circuit for guidance in securities cases is like a trial court relying on expert testimony or an amateur at car repair relying on the advice of an expert mechanic. The judge is persuaded not so much by the expert's reasons as by the judge's inexpert evaluation of the expert's expertise, and thus the source is being used in a genuinely authoritative way, even though the authority is selected by its subject, the judge, rather than being imposed by the system on the subject. We can now see that a common use of an optional authority is not one in which the judge is persuaded by the substance of what an optional source says, but instead is one in which she is persuaded that the source is more likely right than she would be if she made her own decision. So although a judge of the Southern District of New York is required to follow Second Circuit rulings, even if he thinks that all of the judges of the Second Circuit are idiots, the same judge may rely on an optional authority because he is persuaded that the authority knows what he is talking about, even if the judge does not know enough about the subject to know if the authority is actually right. Relying on such an authority is optional and not mandatory. But because it is based on the source and not on the content, it nevertheless counts as a genuine reliance on authority. There is a difference between relying on an authority because the system demands it, as when a lower court obeys a higher one, and relying on an authority because the authority is perceived to be more expert. But both are examples of genuine authority. Even more frequently, optional authorities are employed in a way that hovers precariously on the edge of genuine authority. Thus, when a lawyer in a brief, a judge in an opinion, or a scholar in a law review article makes reference to an authority, it is often to provide so-called support for some proposition. Judges will ask lawyers what support they have for an argument, and student law review editors incessantly ask authors to provide support for what they say. But the idea of support here is odd. The authority alleged to provide support is often not one that supports a proposition more than another authority negates it. This kind of support is a peculiar sense of authority, because the balance of all the authorities might not point in one direction or another, or might even point against the very proposition allegedly being supported. Nevertheless, The conventions of legal citation require only that a proposition be supported by a reference to some court or other source that has previously reached that conclusion, even when other courts or sources have reached different conclusions, and even when there are more of the latter than the former. Often, therefore, to support a legal proposition with a source is to say no more than that at least one person or court has said the same thing on at least one previous occasion. This kind of support may seem close to pointless, and it often is, but it does serve a purpose, especially in a brief or judicial opinion. Providing this kind of minimal support reflects not only law's intrinsically authoritative nature, but also law's related inherent conservatism in the non-political sense of that word. Perhaps surprisingly to many people, a legal argument is a better legal argument just because someone has made it before, and a legal conclusion is a better legal conclusion just because another court has reached the same conclusion on an earlier occasion. The use of an authority that is not necessarily more persuasive or more authoritative than one that could be marshaled for the opposite proposition provides at least the minimal assurance that the user of the authority is not simply making up the argument out of whole cloth. So what conclusions can the reader of an opinion or brief or article draw from the fact that the author has provided assurance of minimal unoriginality? One conclusion would rest on the premise that there are not, proportionally, that many legal propositions whose affirmation and denial are both supportable by respectable published sources. That is often so outside of law, and in science many of the basic principles would be so unanimously supported that respectable published conclusions to the contrary would be non-existent. Were this so with law, then the fact that some conclusion of law had been reached previously by a court or credentialed commentator would be some indication of its soundness. Thus, American judges often use the phrase, "it won't right," to refer to a conclusion they would prefer to reach, but for which they cannot find sufficient support in the available authorities to justify the outcome. In effect, they are saying that some legal propositions, even some legal propositions that would generate a desirable result in the particular case, are simply not legally supportable. The question, however, which we will take up in the discussion of legal realism in Chapter 7, is the frequency with which this is so, that is, the frequency with which one or another possible outcome in a case will not right. If some citation to a case, rule, or principle is almost always available to support virtually any legal conclusion, as legal realists such as Carl Llewellyn sometimes insisted, then the requirement of support will not be much of a constraint. But if, in contrast, the existing stock of authorities, even optional and not mandatory authorities, is often entirely on one side of a legal question, then a requirement that legal conclusions be supported by legal authorities will genuinely constrain a judge's decisional freedom. The extent to which this is so, however, is an irreducibly empirical conclusion, and with respect to this conclusion, as we will see in Chapter 7, opinion is deeply divided. If Llewellyn was even a little bit correct, the requirement for some support may often not be very constraining on a judge. But it is worth noting that requiring minimal support is still a form, albeit a weak one, of genuine authority. The author of a brief or opinion who provides some support in order to deny genuine novelty is asking the reader to take the supported proposition as being at least slightly more plausible because it has been said before than if it had not been. And this is being done, typically, on the basis of the very existence of the source itself, rather than of the substantive reasoning contained in it. One could well ask why the legal system is so concerned about the existence of one supporting authority, even when the weight of authority might go in the other direction. But although the practice is questionable, the point is only that even this weaker and arguably more common form of citation to authority is a variant on genuine authority and is consistent with the authoritative character of the law itself. The lawyer who points to an authority for support is in effect claiming an endorsement for her argument, and in law, as in life, having one endorser is at least better than having none at all. 4.3 Why real authority need not be binding. But what of mandatory authorities? Are they as binding as the traditional terminology suggests? The answer depends on what is meant by binding. And it turns out that speaking of binding authority can be just as misleading as speaking of persuasive authority. Typically, when we imagine a rule or constraint as binding, we think of it as unavoidable, as leaving no choice. Binding constraints are those we suppose to be absolute and incapable of being overridden by other considerations. The image of a binding authority is most commonly an image of an authoritative constraint from which the decision maker cannot escape. If a precedent is binding, then a court bound by it simply must follow it. Period. There is no reason, however, why even a binding authority should be understood in this way. Although a binding authority creates an obligation on the part of the bound court to use that authority, such an obligation, like any other obligation, need not be absolute in order to oblige. In life as much as in law, genuine obligations can be overridden by even stronger ones without losing their force as obligations. I am obliged to keep my promises, so it is said and so I believe. And thus I must keep my lunch date with you, even if I no longer find you interesting, or have subsequently received a better offer. But if a close relative has fallen ill, it is understood that my obligation to keep my lunch date is overridden by the even stronger one to attend to ailing relatives. And when the police officer refrains from giving a speeding ticket to the man who is rushing his pregnant wife to the hospital, the officer properly understands that the obligation to obey and to enforce the speed limit can be outweighed by a still more pressing obligation. Indeed, rights operate in the same way. It is not that the government may never, under the Equal Protection Clause of the 14th Amendment, draw a distinction based on race. Rather, the government may draw such a distinction only if it has a compelling interest in doing so, and the fact that the interest must be compelling rather than simply substantial, legitimate, or rational shows exactly how a right, like a rule and like an obligation, can make a genuine difference without being absolute. What there is a reason to do is different from what should be done, all things considered, just as what there is a right to do is different from what the right holder actually gets to do, all things considered. Just as obligations can be obligatory without being absolutely so, so too can authorities be authoritative without being absolutely authoritative. The existence of an authoritative reason is not inconsistent with there being other outweighing authoritative reasons or outweighing reasons of other kinds. Most authorities are therefore not binding or controlling in the absolute sense, and treating a source as authoritative or even mandatory does not entail following it come what may. A judge of the United States District Court for the District of Maryland is bound by the decisions of the Court of Appeals for the Fourth Circuit, but he is also bound by the decisions of the Supreme Court. And if in some case the relevant Fourth Circuit precedent turns out to dictate one outcome, while the relevant Supreme Court case indicates another, the obligation to follow the Supreme Court will override the obligation to follow the Fourth Circuit. Similarly, the best understanding of stare decisis is that a subsequent court is bound to follow the earlier decisions of the same court. But this too is not an absolute obligation. When the Supreme Court says that it will only overturn its own precedents when there is a special justification for doing so, it is emphasizing that it is not sufficient for overruling that the court now believes that the previous court was mistaken. Something more is required, something special, but there is no indication that this higher burden of justification cannot on occasion be satisfied. In this respect, the Supreme Court's approach is consistent with that of appellate courts generally, which typically retain the power to overrule their own earlier decisions, but which emphasize that overruling is exceptional, and that it will occur only when the reasons for doing so are especially weighty. The earlier case is a binding precedent, but here, unlike in the situation involving vertical precedent, where we understand binding to mean non-overridable by any other consideration, the binding force of stare decisis is real but decidedly non-absolute. For can there be prohibited authorities? We have distinguished mandatory from optional authorities, but we need to return to the idea of a prohibited authority. Are there sources that simply may not be used at all? It turns out that the answer to this question is yes, although the issues are complex. Consider, for example, the practice of some American courts, especially federal courts of appeals, of issuing no citation or no precedential effect rules encompassing many of the cases the court decides. Under these rules, the court typically issues with its judgment a brief opinion for the benefit of the parties. But by the court's rules, that opinion, even if publicly available, can be neither cited nor relied upon as authority in subsequent cases. The practice has generated controversy, and in the federal court's Rule 32(1) of the Federal Rules of Appellate Procedure now prohibits the individual circuits from issuing no citation rules, even though Rule 32(1) says nothing about the ability of a court to declare that one of its decisions will have no precedential effect, just as the Supreme Court's denials of certiorari have no precedential effect. But although no citation rules have been eliminated in the federal courts, some of them still exist in the state courts, and they have the effect of creating a class of prohibited citations, prohibited sources, and prohibited precedents. Moreover, the still permitted practice of designating some opinions as having no precedential effect verges on treating such opinions as prohibited authorities. Even with the recent change in the rules, therefore, the question persists. Does a court get to control what will count as precedent before it? And can it say that some of what it decides cannot subsequently be used? If we view precedents simply as predictions, it seems odd to prohibit their use. But it seems even odder, as we will see in Chapter 7, for someone arguing before a court to be predicting what that court will do, as opposed to urging the court to do what it should do. If we persist in the strange belief that courts do not make law, then perhaps a judicial decision can be understood as evidence of the pre-existing law, and under this premise, it would be questionable to prohibit a lawyer from providing to a court any available evidence of what the law is. But a judicial decision is not evidence of what the law is. It is the law. And if it is the law, then there is no reason why a court, any less than a legislature, should not have the ability to decide when it will make law and when it will not. In treating some sources as in effect not authoritative at all, courts adopting no citation or no precedential effect rules appear to be worried that what the court may have said entirely for the benefit of the parties, and with little consideration of the implications for other cases, will be used as reason in subsequent cases. These rules are ones by which a court denies the authority, and not only the absolute authority, of its casual, rushed, or largely party-focused statements. And there seems little reason that we should deprive courts of the power to do just that. There is a parallel here to the 2006 decision by the Middlebury College Department of History to prohibit students from citing Wikipedia in their class papers. The department's worry was not primarily that Middlebury students would take whatever is on Wikipedia as unchallengeable gospel, but rather that the students would take Wikipedia entries as serious sources of information and authoritative guidance. Indeed, Middlebury's prohibition on Wikipedia is similar to the strong warnings against citation to corpus juris secundum or American jurisprudence routinely included in legal writing instruction for law students. And perhaps the prohibition on Wikipedia is also analogous to the Supreme Court's boilerplate statement in every one of its decisions on the merits that the syllabus of the decision is prepared by the reporter of decisions, not the court itself, and accordingly is not to be treated as authoritative. Some of the considerations that influenced the Middlebury History Department also apply to the hotly debated question of whether American courts should cite to or rely on foreign law, a debate that surfaced in Supreme Court opinions on capital punishment and homosexual sodomy, and has been widely discussed in the law reviews. For Justice Scalia and other opponents of citation of foreign law, the concern is not that foreign law would be considered absolutely binding, because no one has urged such a position. Rather, the opponents worry that the typical reference to foreign or international law, even if optional, treats foreign law as a legitimate source, albeit not a binding one, and thus as genuinely authoritative. For Justice Kennedy in Lawrence v. Texas, for example, the practices of the countries whose decriminalization of homosexual sodomy he cites are reasons for the United States to come to the same conclusion, even if those reasons are far from conclusive. Like other optional references to authoritative sources, the Tenth Circuit's reliance on the Second Circuit and the Second Circuit's reliance on Loss and Seligman, for example, neither the optionality nor the non-absoluteness of the use of an authority is inconsistent with that authority's authoritativeness. To cite something is typically to imply that it is to be taken seriously, and those who would treat the citation of foreign law as questionable or impermissible, just like the appellate courts that prohibit citation to some of their less carefully considered opinions, wish to establish that some sources simply should not be taken seriously. Debates on this issue are likely to continue for some time, and they raise issues about democracy and lawmaking that are not germane here. But it is worth bearing in mind that these debates are about which sources should be taken as genuinely authoritative, even if not absolutely so. This is a debate that goes to the heart of the authoritative character of law itself, as the ensuing section will clarify. 4.5 How do authorities become authoritative? Although we can distinguish between mandatory and optional authorities, the difference turns out to be one of degree rather than one of kind. In theory, it would be possible for sources to become authoritative by virtue of a single discrete act, as with the provision in the West Virginia Constitution recognizing certain legislative decisions of Virginia of which West Virginia had formerly been a part courts as authority in West Virginia. Far more commonly, however, the status of an authority as an authority is the product of an informal and evolving process by which some sources become progressively more authoritative as they are increasingly used and accepted. It was formerly the practice in English courts, for example, to treat as impermissible in a lawyer's argument or a judge's opinion a reference to a secondary source written by a still living author. If the author of a treatise or rarely an article was dead, then citation was permissible, but not otherwise. The reasons for this practice remain somewhat obscure, although apparently it developed out of a concern that it was far easier for those who are still living than those who are dead to change their minds. What is important, however, is that the prohibition gradually withered, a withering that commenced more or less with the citation by the House of Lords in 1945 to a work by the then still living Arthur Goodhart. Once the first citation to a living secondary author appeared, subsequent courts became slightly less hesitant to do the same thing, and then less hesitant yet. And over time, the practice became more widely acceptable. There is nothing unique about the example of still living authors of secondary sources. Rarely are there formal rules determining what is to be recognized as law. What the British legal philosopher H.O.L.A. Hart influentially called the rule of recognition is far less a rule as such than it is a series of continuing changing practices or conventions, much like the fluid practices or conventions that constitute a language. And so too are there rarely crisp rules that determine which authorities may legitimately be cited in a legal brief or argument or opinion. Rather, what counts as legal authority, and thus what counts as a legitimate source of law, is the product of an evolving practice in which lawyers, judges, commentators, and other legal actors gradually, and in diffuse and nonlinear fashion determine what will count as a legitimate source and what will not, and thus will, in the same fashion, determine what will count as law and what will not. Justice Scalia, the Middlebury History Department, and the guardians of the no citation rules, thus have some genuine basis for worrying that legitimizing the use of this or that source will set in motion a considerably more expansive process. Indeed, a legal citation has an important double aspect. A citation to a particular source is not only a statement by the one citing it that this is a good source, but is also a statement by the citer, especially if a court that sources of this type are legitimate. Thus, we frequently see a progression in authoritativeness from prohibited to optional to mandatory, a common process by which sources become transformed from decidedly non-legal stuff into mandatory authorities. Although the 10th Circuit would be doing nothing wrong in the technical sense in failing to cite to the 2nd Circuit in a securities case, the failure to cite to the most prominent court on securities matters would be apt to raise some eyebrows. And the higher the eyebrows are raised, the more what seems superficially optional is in reality virtually mandatory. The more there is an expectation of reliance on a certain kind of technically optional authority, it is virtually impossible to argue or decide an evidence case in the Massachusetts Supreme Judicial Court, for example, without referring to Liakos's Handbook of Massachusetts Evidence the more an authority passes from optional to mandatory. Thus, for Justice Scalia and others with reference to foreign and international law. For legal writing instructors counseling first-year law students about which authorities are permissible citations and which are not. And for appellate courts wrestling with no citation rules. What may appear to be minor questions about form are in fact fundamental questions about what is to count as law. When Justice Breyer, in Parents Involved in Community Schools v. Seattle School District No. 1, provided 3 pages of sources, mostly historical and administrative sources not in the briefs or the record below. His citation practice not only speaks to what for him counts as law and what it is to do law, but also serves an authoritative function, although it would have been more authoritative had the opinion not been a dissent in telling lawyers and judges what they can use to make a legal argument, and thus in telling lawyers and judges what law is. Because law is an authoritative practice, a great deal turns on what the authorities are. Why the Supreme Court and the Congress of the United States, but not the editorial board of the New York Times? Why the Federal Trade Commission, but not the board of directors of Walmart? Why Lawson Seligman, but not Marx and Engels? Why the Harvard Law Review, but not the Village Voice? Why the writings of Thomas Jefferson, but not those of Jefferson Davis? None of these seemingly rhetorical questions is strictly rhetorical. At least in American courts, citation practice is undergoing rapid change, and there has been a great increase not only in citations to non-American sources, but also to sources that not so many years ago would have been sneeringly dismissed as non-legal. In Kumho Tire Co. v. Carmichael, for example, a case dealing with the qualifications of expert witnesses, Justice Breyer's majority opinion referred to a book, not cited below, entitled How to Buy and Care for Tires. Justice Breyer's willingness to depart from traditionally legal sources, however, is hardly unique to him. In PGA Tour Inc. v. T. Martin, the Supreme Court, with Justice Stevens writing for the majority, relied on and cited to a number of non-legal sources again, sources not in the record, but located by the justices or, more likely, their clerks about the nature of golf, in order to decide whether allowing a professional golfer with a circulatory ailment to ride in a golf cart in violation of the rules of high-level professional golf was required by the Americans with Disabilities Act. And in Bush v. Gore, the majority thought it important to frame its entire decision with the proposition that 2% of all ballots cast in a presidential election do not register a valid choice for president. The court plainly thought this important. The proposition gets its own subsection in the opinion, but to reach this conclusion, it relied on several newspaper articles that it located for itself, one from the Omaha World Herald, for example, which document this historical phenomenon. These examples are hardly exceptional. With increasing frequency, certainly in the United States, and to some extent in other common law jurisdictions, lawyers and judges have been citing to, and sometimes relying on, material contained in non-legal journals from economics, sociology, psychology, and political science, in books about subjects other than law, and in articles in newspapers and popular magazines. If seen as just a change in citation practice, this might be at best an interesting shift in the form of judicial opinions. But these changes do not merely reflect a transformation in citation practice. They embody a change in what counts as a legal source, and thus in what counts as a legal argument. And what counts as a legal argument as opposed to a moral, religious, economic, or political one is the principal component in determining just what law is. The boundaries of law are set by the boundaries of legal authority, and law speaks as law through its sources. When previously prohibited authorities become optional, and when previously optional authorities become mandatory, the nature of legal sources has changed, and with that change comes a transformation in the nature of law itself.